Welcome back, folks. Took us a little bit longer than we thought to dial up our next guest, who is someone who is very close to this U.S. Supreme Court decision to reject Brendan Dassey's petition for certiorari before the U.S. Supreme Court. Len Kachinsky was Brendan Dassey's attorney for a little time, and it's been a good long while since we've talked face-to-face, Len. Good to see you here on Law&Crime.
Well, it's nice to be here, Aaron.
So what do you make of this? It was a long shot to get this case in front of the U.S. Supreme Court. They ultimately denied it. A lot of people are really upset about this because a lot of people watched the Netflix film. A lot of people really felt sorry for Brendan Dassey. Statistically, though, it's not much of a surprise for this case not to have been picked up.
That is correct, and the real issue on the case was a contention by Dassey's appellate team that you can't get a valid confession from a 16-year-old unless you have a trusted adult present. That's never been the law anywhere that I know of. So it was a kind of a novel argument. When we did the motion in front of Judge Fox, we presented all the evidence about his school background and psychological testing that was done there. And of course, the judge, as well as the Court of Appeals and everybody else, saw the 4.5-hour video.
Yeah, I mean, so, Len, look, that's part of the argument. Part of it is that this was just a coerced confession, because the interrogators were older and presumably smarter than Brendan Dassey. But you represented Brendan Dassey for a little while in this, and in the film, you really got a bad name. Is there anything you'd like to say to respond to some of the criticism that hit you?
Well, first of all, the 4.5-hour interrogation was before I was ever even on the case. So it was done back then, I think a couple of weeks before I was on the case. The one interrogation that took place when I sent my investigator instead of going there myself was never used at Brendan Dassey's trial. Now, the jury and Judge Fox and the Court of Appeals, all saw this 4.5-hour video and can make up their own mind, looking at all of it and with the assistance of arguments from the attorneys that actually tried the case, Mark Fremgen and also Ray Adelstein, whether or not it was coerced. I mean, seeing is believing. That's the beauty of a videotape that was permitted by, or actually required by the Jarrell decision about 1.5 years before Dassey's statement. So people saw it. Dassey's appellate team has its own take on it, but other people that saw it apparently saw it differently.
Yeah, Len, I know that, if I'm not mistaken, you were still on the case when the suppression hearing was lost. So you tried to make this argument that is still basically the argument that's carrying the day here, and which today did not carry the day, in front of the U.S. Supreme Court. But everybody tried to get this confession thrown out, correct?
Correct. And, I wrote a long brief for Judge Fox, citing all the different factors you're supposed to look at under the Jarrell decision as to whether or not a statement is voluntary, and everybody got to see the whole thing. So it's no surprise that they saw it differently perhaps than Dassey's defense team.
I can understand that. I've written before about this case, Len, at the request of some bar publications and whatnot, and in one of those articles I said that I could rationalize some of your decisions, but not all of them. I mean, the allowing of the interrogator to interview Brendan Dassey without you present, I'm not sure I can rationalize that.
Well, I don't either. That was a mistake.
I'm sorry?
That was a mistake. No.
Okay. So hopefully people are willing to forgive you for that. That said, I got to ask you this. I mean, at this point, Brendan Dassey really is almost out of options. And I've got some articles about what, in theory, could happen next up on lawandcrime.com for those of you who want to take a look. But, Len, look, I don't know if you want to get into this with me or not, but was it, well, I think we may have lost Len Kachinsky. We're going to try to bring him back. We do have some more clips of Brendan Dassey's interrogation. We want to listen to one of those really quickly. We'll try to get him back because this is a really critical question.
We know he made you do something else.
What was it?
That he punched her.
What else? It's okay. What do you make you do?
Cut her.
Cut her where?
On her So,
You cut her throat. What else happens to her in her head?
extremely, extremely important you tell us this. For us to believe you.
Come on, Brendan. What else?
We know, we just need you to tell us. That's all I can remember.
Some of Brendan Dassey's police interrogation, and one of his attorneys in this whole ordeal was Len Kachinsky, who didn't make it all the way to trial, but he's joining us here on the Law and Crime Network. Len, I got to ask you, you know, the U.S. Supreme Court declined to take the case today, so that means that the lower court's decision will stand and that Brendan Dassey will remain in prison. Do you think Brendan Dassey should have accepted a plea deal, and would that have gotten him some freedom before another potential appeal, even if it gets to that?
I had discussed it with him, and I think it's probably well known what I probably recommended to him, but it's ultimately his decision. If he says he didn't do the offense, he shouldn't have accepted a plea deal.
What was the state's offer?
It's been so long ago, I don't even remember precisely what it was. I think it was something that would have been a recommendation for around 20 years or so instead of the 40 years that he got from Judge Fox before he was eligible for extended supervision.
And as we wrap things up here, Len, I know that, as I said before, a lot of people were concerned about your performance and you were sort of vilified in the film now. Is there anything that you need to say to set the record straight, to try to clear your own reputation? Anything you want to say in support of Brendan Dassey or to the people who watch the film?
Well, essentially, people that watched the Netflix video got the impression that I tried the case and I was responsible for Brendan Dassey being in prison. The fact of the matter is that the Wisconsin Court of Appeals and even Magistrate Judge Duffin concluded nothing I did contributed to Mr. Dassey being convicted and going to jail. His attorneys at the trial level, Mr. Fremgun and Mr. Edelstein, had the opportunity to make this argument to the jury, the same one that the appellate team made to the Supreme Court and to the Seventh Circuit, that there was coercion and leading questions and otherwise the confession was unfair. They didn't successfully do it, and they're the ones who were actually there on the line when the jury found him guilty.
Do you think this confession should have even made it in front of the jury?
Well, I argued, you know, in front of Judge Fox that it shouldn't have, because it was because of his age and his mental status and so forth. He decided otherwise, looking at all the factors in the case and just looking at the 4.5 hours of video. With videotape confessions, a lot of time it's, you know, seeing is believing, and the jury and the appellate courts apparently believed that it was a reliable enough confession, and the jury apparently believed it was reliable. So I never make an opinion on a case whether or not my client committed the offense, and I'm not going to do it in this one. I can just say that having seen the video, I can understand why persons came to the conclusions they came to. I don't think it's terribly as outrageous as some people claim it was. I think they were reasonable decisions. Perhaps I disagree with them, but they were certainly based on the evidence.
How so?
Well, if you look at the whole 4.5 hour video, it was very non-leading in almost all the parts of it. It was a very soft touch type of interrogation. The Jarrell case, for example, was 16 hours. This was only 4.5. It was a pretty long series of events. So I just looking at it when I saw the 4.5 hours, I think you could come to the conclusion that Brendan was rational, responsive, and understood what was going on.
So are you defending the interrogators here?
Well, I mean, I'm not defending them. I'm just saying they were defended by the Court of Appeals and the Seventh Circuit as having these techniques that were quite common for other types of cases. Now there's, he's 16 as opposed to 18. Is there something magic that happens between those two ages? I don't find anything. I said it was certainly, there were persuasive techniques used, but it's up to the judge to decide whether or not they cross the line. So I'll just defer to the rulings of the court.
Does Brendan Dassey deserve to be let out of prison, in your opinion?
Well, given the judgment of the court and with the laws that we have in this state, and the fact I think that they were faithfully executed, I'd have to say no, unless he can get a pardon or clemency from the executive branch.
And your current governor in Wisconsin has said that that's not an option. So, look, we could keep going around the issues in this for quite a while. But Len Kachinsky, a person who I interviewed many times, many years ago when these cases were live in court up there in northeastern Wisconsin, appreciate you joining us today on the Law and Crime Network.
You're welcome, Aaron.
All right, well, we're going to wrap this up. Again, if you're just joining us, U.S. Supreme Court refusing to take up a petition by Brendan Dassey of making a murderer for that court to hear his case.